Well, that was a fascinating, and I think for many communities, many countries who have tried to introduce non-rigid and legal systems and to try to bring in some type of tradition, some type of just human feeling into, I think many have gone through similar issues, but do we have any, yes?
You are going to say questions, right?
Yes.
Okay. Okay, thank you very much for that presentation. I had two things that I wanted to say. One of them is that when you were beginning the presentation, you were saying that when they were introducing ADR, the chiefs also went through training. And I'm curious to find out if the intent is to try and bring traditional justice to the same level as the formal justice system. Why would you train chiefs on a practice that they have already been practicing? So it's almost like you're introducing them to something new, and yet you are saying, because you've been doing this, we'd like to incorporate it into the formal justice system. So that's one question. The second thing that I wanted to say is that when the European Union did a study of their member countries and the use of mediation, after the mediation directive had been in place for 10 years, they actually found that the only country that had succeeded in using mediation at a level that was quite high was Italy. And the reasons why Italy distinguished from all the other countries was because Italy's mediation was compulsory. Italy then removed the compulsory nature of their mediation, and they saw a drop in mediation. So I would like you maybe to comment on that in contrast with what you just said about compulsory mediation.
Sure. Well, going back to the chiefs, that's a really interesting question. I think there was a strategy behind a strategic purpose for getting the chiefs involved in the mediation training. And I'm actually speaking from my experience in working in Sunyani with a group that came down, a Western group, but also working with Ghanaians. And the idea was that if the chiefs bought into the new ADR law and the modern versions, if you will, self-determination issues, et cetera, of mediation, then it would become much more accepted in the community. So it was a really share with them what this law is about and get their approval. Without their approval, we're not going to do very well. And in fact, some of the chiefs trained in our court mediators in the Sunyani area. So that was the reason of involving chiefs in the training, some of the trainings. And it was, I mean, they only went if they wanted to. So the EU thing is very interesting. I have a colleague who's from Italy, and he writes articles all the time about the Italian experience. So I know that when you make something compulsory, people have to come. But I also know from statistics in the US that look at the enforceability statistics of contracts made in mediation. The highest number of litigated cases in the US are over the enforceability of mediated agreements. People's buyer's remorse. After they mediated, they wanted out. So why is that? I think there's a strong correlation between the compulsory mediation programs that we have and the agreements that parties made under them, that they're not going to, there's no long-term durability. So that's why you have a concern about compulsory. However, right now, my understanding is there's a proposal in the EU that Italy, I think, is very much pushing for opt-in and opt-out on mediation. And apparently there's been good success with the opt-out, making everything mandatory and then but giving the parties the right to opt out. Nothing's obviously been passed yet, but that's, I think, where people in Italy who are pushing for this want to go. Good questions. Thank you.
Thank you very much for your presentation. I strongly believe in the significance of ADF. So the problem I have with it is this. In countries, diverse countries like Nigeria and other countries in sub-Saharan Africa with huge number of ethnic diversities and religious diversities, how do we make alternative dispute resolution work in such countries? And I know you've alluded to the issue of enforceability of the agreement. So, but my concern is still about the significance, the potential impediments of diversity on enforceability of alternative dispute resolution. Thank you.
I'm not quite sure. The potential, you're concerned about the potential of enforceability of the agreements made?
The question I tried to ask is, ethnic diversity, ethnic and religious, cultural diversities tend to impede that ethnic, religious, and cultural diversities are likely to impede enforceability of alternative dispute resolution. So what's in your study are you proposing to ameliorate such potential impediments?
It seems to me when you're trying to introduce a system like ADR into a country, you have to do a sort of a cultural compass and see what the ethnic groups are and involve everyone as stakeholders in the whole strategy to push this forward. So I'm not sure I'm answering your question, but I think you have to recognize all the players, and the players will be all the ethnic groups, and design a process that includes all of them in training and in passage of this legislation, and more training afterwards. And to make sure that in the court-connected programs, which is where a lot of the action is happening, that you have ethnic diversity of the mediators there, which could be a real problem. I think you're getting at, yeah.
Pat Mkiza, my name, Prof. I'm sure you may be aware that South Africa, Department of Justice, looked at Ghana's model of dispute resolution. They also assessed it. But having done so, I would say, unfortunately, that our own court-connected mediation program is not working. What is it that you may tell me in particular? Because I want to contribute towards the success of this court-connected mediation project in South Africa. What is it that you'll tell me to be considered by the Minister of Justice, the Justice Department, so that their program it takes off?
Right.
Because
right.
it's not even taking off. I know something was done, but it has collapsed. It's only us practitioners who are trying to make it alive. What is it that you may perhaps indicate or suggest to me
Short of
as somebody who's coming from that situation?
And now you have to eat my words, because short of making it mandatory, nothing gets up the numbers like mandatory mediation, right? But I think there are ways that you can make it as a first step. You can refer parties to have an educational session about mediation. You can require parties to go to an initial, call it an information gathering about mediation. And only until they do that, they can either then choose to go to mediation, or then they can choose to go into court, but they have to go for some initial session. I don't have a problem with that, and I think it's not mandatory, but it's quasi-mandatory. It gets the parties to hear the story, to taste the dessert, if you will. I mean, that's in terms of getting numbers. I think obviously quality training of mediators is very important. A few parties have bad experience with mediators who are not well trained, who are coercive. I think that's a turnoff, and then in the community, the word spreads about what court mediation is really like. So I think quality training of mediators is very important. I think it might be useful to start with selected categories of cases. Don't try everything at once, but just take, foreclosure cases or selected commercial cases and try to find success in one area and then build on that. But I think somehow parties have to know, it's more than the judge saying, go off and try mediation here. There has to be some requirement that you go and sit down and hear about this, whether you watch a video about see what it looks like, or hear about it, some sort of, you want to have informed consent at the end of the day. So this is the informed part. How are they going to inform them? And you can require them to be informed, to listen.
Prof, with respect, let me interrupt you. At individual level, at individual level, people are aware because mediation in South Africa, for example, began as early as 1972, but in the labor sector. I am specifically asking you to suggest at governmental level so that this thing takes off. You see, the compulsory level, my thesis, my LLM thesis, I can't hide that. I made recommendations that we must have a mandatory approach to institutionalizing.
That's a terrible word.
Yeah. Because people, particularly people who want to access justice, they're not able to do so, particularly in rural areas. So for it to take off, for people to get acquainted with this approach, it will need a bit of compulsory elements for it to take off. Minister of Justice in South Africa, initially when they introduced it, it was mandatory. But we said, no. To introduce it as mandatory, we must have a statute. And then they had to change to make it either compulsory or not compulsory. It's a mixed masala. So I'm asking you, what is it that may be done at government level to make it work, not at individual level?
I'm thinking a couple of things. One is a huge buy-in by the judiciary. I mean, just even though it's not even law, it's just lots of public statements and acknowledgement by the judiciary that they're fully supporting ADR, that this is the way to go, et cetera. But I think on a regulation level, for example, look at something like the rules of civil procedure that govern court actions. A quasi, not, I hate mandatory, but a sort of a combination, a hybrid with you of mandatory and voluntary. This requirement that before your case proceeds to the trial docket, you need to show that you've met with a mediator and had a discussion about mediation, something along those lines. And you just, some stuff gets lost in translation, but you just know that, you say people know about it, but the mediator, I mean, is going to be trained to point out the advantages in this particular case for you to try to settle. I mean, it's going to be very contextual towards that person. That is a bit mandatory because you can't go any further if you don't do this. I have to think that's going to capture some of the parties into it. I think you just need some good success stories that are going to spread.